today, Shannon?
All right, we'll get started here. Just want to, first of all, welcome everyone and thank you for joining us today for the presentation on Problems of the Rich and Famous, Solutions in Supersized Teams with Carrie Heinzl, Jason Kwiatkowski, Jarret Johnston, and Russell Alexander. My name is Shannon, and if we haven't met before, I'm part of the community and events team at Russell Alexander Collaborative Family Lawyers. I'm just going to start with a bit of housekeeping, and I'll let you know what's on the agenda before we get started today. Before I pass things over to the panelists. And following that, I will be behind the scenes for most of the presentation once I pass things over to our panelists, and I'll be available for any questions or tech issues that may come up. So you'll notice that the chat function has been disabled.
Does that mean we can give you all the tough questions since you're available?
I mean, I don't know if I will be able to provide as informed answers as all of our experts here on the panel.
Good answer, good answer.
She hedged her bet.
I'll do my best or direct the questions.
I will not interrupt you for another 1 minute. How's that sound?
All right, deal. Clock is on.
All right.
So in this 1 hour presentation, Russell, Carrie, Jason, and Jarret will be discussing the nuances of family law cases with high profile and high net worth clients, covering the following topics: the need for privacy and security, obtaining disclosure, small, medium, and large-sized businesses, the role of adult children and the Greek chorus, advantages and disadvantages of process options, dividing assets, tax planning and advice, spousal support, new partners, support considerations, and estate and legacy planning, and famous or infamous. And once the presenters have shared their closing thoughts, there will also be a Q&A, a dedicated Q&A segment at the end of the presentation. So if you haven't already, please feel free to submit your questions, as I mentioned, via the Q&A box, and we'll do our best to get to your question during the presentation. And we just asked that everyone keep in mind that the content of this webinar is to provide general information on separation and divorce, and should not be considered as legal advice. And just also another note before I get into our introductions, that I'll be sending additional resources in a follow-up email tomorrow to all of our audience members. So keep an eye out for that. So now, without further ado, it's my pleasure to introduce today's presenters. First of all, we have Carrie Heinzl. So Carrie Heinzl is the founder of Fairmore Family Law Financial Solutions. Fairmore offers independent, fact-based financial analytics and settlement insights to individuals and couples working through separation and divorce. And Carrie is an active collaborative process trainer, co-teaching the introductory program for new collaborative professionals and advanced level trainings for the seasoned practitioner. Carrie has taught statistics, research methodologies, and psychology at college and university levels. In addition, Carrie has presented at conferences for the Ontario Association of Collaborative Professionals, Family Dispute Resolution Institute of Ontario Annual Conference, and the International Academy of Collaborative Professionals. Next, we have Jason Kwiatkowski, and Jason is a founding partner and the president at Valuation Support Partners Limited, a professional services firm specializing in providing the business and legal communities with business valuation, litigation support, and exit planning advisory services. And Jason is an independent financial neutral and has completed numerous business valuation and expert reports, including income assessments for various purposes. And Jason has testified before the Ontario Superior Court of Justice as an expert witness in business valuation and damages quantification. He has authored many articles and spoken before various professionals and business groups. Next, we have Jarret Johnston, and Jarret practices primarily in family law, specializing in litigation, collaborative, and traditional settlement work. Jarret also offers services in wills and estates and real estate. Jarret sits on the executive board for the Kawartha Collaborative Practice, the executive of the Victoria Halliburton Law Association, and is a director for the Children's Services Council. Jarret is passionate about getting his clients the best results possible with the least amount of financial, mental, and emotional damage, whether in the boardroom or courtroom.
Jarret, what happened to your high school yearbook photo? That's a pretty updated photo.
Well, I wanted to show the true character of the wrinkles in my face, so I had to update.
Botox, Jarret, Botox.
He's an experienced lawyer now.
He's a big boy now.
And of course, we have Russell. Russell is the founder and senior partner of Russell Alexander Collaborative Family Lawyers. With over 20 years of experience, Russell offers a wealth of knowledge and expertise in collaborative family law. He uses his experience with a client-focused approach by creating unique solutions for each of his clients to enable them and their families to move forward with their lives in a compassionate and collaborative manner. And now that you know a little bit more about our panelists today and what's on the agenda, I'm going to pass things over to Russell to get started.
Thank you for the kind introduction, Shannon. Let's run our first poll. Oh, what's this? What we got up here? We got an ebook coming up.
Yeah, so just to let everyone know, there will be a survey that pops up at the end of the presentation. So if you can provide your feedback, it's really great for us just to take into consideration for future planning for our event series. And just as a sign of our appreciation, we'll be providing a complimentary ebook to those who provide their feedback.
Free ebook, how can you go wrong? Let's run our first poll. And Carrie, you've got training coming up, I think this week, right? Online CP training?
We have collaborative practice training. It is starting on November the 8th, and there's still time to register. We have a couple of slots still remaining. So, and anybody can register at cptraining.ca.
Yeah, let's get the link in the box. It's a great program run by Brian Galbraith, I think Bev LeMay. Our new associate David's joining you. I don't know if you knew that yet.
Oh,
So,
that's wonderful. Oh, we look forward to having him.
you signed
Well,
up.
one of the things that, Russ, that you may not know, which is kind of unique for our training group, is that Brian Galbraith is now the president of the International Academy of the Collaborative Professionals, and I'm now the vice president of the Ontario Association of
Oh,
Collaborative Professionals.
congratulations.
Yeah,
Does that mean we got to
Excellent.
salute you every time you come in the room or what?
Yes, yes, Madam Vice President is just fine. I'll accept that.
Well, we've got lots of people from our audience wanting to learn about CP training. So take a look at what Carrie's got going on. Starts next week. We'll put a link in the box. I just want to say how much I love doing these programs. We really have a dream team together today. We've got Jason, Carrie, and Jarret. Fantastic presenters. Want to thank them ahead of time for donating their time today to be with us. We're going to do polls throughout, so please answer the poll questions. The first one's tell us a little bit about yourself. It helps us understand our audience and helps us engage the audience a little bit more. There's the Q&A box. Please put the questions and answers, or you put the questions in, we'll try to give you the answers. Apparently that other profession's available. Legal in Amsterdam, Carrie. I saw that come in the Q&A, just to let you know.
Yeah.
So give us your feedback. Just to let you know, we do sometimes use humor as a teaching tool. Not everybody likes our humor. We don't go from a script, we just go off the top of our heads. So I apologize in advance if you don't like our sense of humor, but it makes it a little bit more engaging and fun.
They
So let's
they
make a
tend to
start.
they
Pardon me?
tend to pick on me a lot, just so.
Well, you're such an easy target.
It's out of love. It's completely out of love, Jarret.
Totally, totally. We were even talking about your bathrobe before you got on the screen, and then everybody went silent.
It's true.
72%. Wow. Legal
Wow.
professional, other person practicing family law. So welcome to our colleagues. A lawyer in another profession, 10% almost. Outside of the industry, 12%. Going through separation and divorce. We have a student with us and another person. So thank you for joining us today. We're certainly going to have fun with this topic. Let's talk about the need for privacy and security. So we're talking about rich, famous, infamous, we're going to, and they're going through a divorce, right? So they've got some unique problems, but Carrie, privacy and security, what are the rich complaining about?
Well,
Why do they need privacy and security, I guess?
There's a few reasons for it. When people are wealthy, they can become targets. So there's a personal safety concerns. When you're going through a process, especially if you're in a litigation, your stuff is public record. So anybody with an active credit card can go in and pretty much get any information they want on you. And that includes social insurance numbers, your bank account numbers, and all sorts of information. And if you own a business, it's even more important because they can get information regarding your business.
Your competitors.
So, yeah, absolutely. So,
Right.
There's some really famous ones I think we're going to talk about a little bit later where, things get played out in the media, and there's so much with social media now and regular media outlets that we can find out way too much. Not all of it's good information. Some of it is quite salacious. And I think what we want, and especially if people are wealthy, We want that privacy. We want that security. And one of the best ways you're going to get privacy and security is going through the collaborative process. The other thing that's nice about it is it becomes a concierge service.
Excellent. Thank you. Let's go to our second poll. What disclosure issues are unique to the rich and famous? So, you know, privacy and security is really important, not to every family, not just the rich and famous. But it's amazing when you see support claims involving wealthy families, the budgets that come out, right? You know, I saw one, the wife had a $15,000 a month wine budget. Like, it really is a different world that these people are living in, right, Carrie?
Some of them are pretty interesting. I remember on one matter that is a wealthy Canadian family that the food, pet care, dry cleaning, and meals was $12,000 a month.
Right.
I don't know how you eat that much food and how many animals they had, but that's a lot.
I don't
People
think
love
it
their
was
dogs.
Yeah, I don't think it was a farm family.
I know it. I honestly, like, some of the stuff you look at and it's like, wow, travel expenses of $16,000 a month. And I'm looking at that going, okay, that's like for 4 years.
Yeah, you stop losing sympathy after a while, right? When you start taking a look at these budgets.
Yeah, some of them are
The
interesting.
support claims are outstanding as well.
Oh, 100%. Like
hundreds of thousands of dollars a month.
And you look at that and you're like going, what they're getting in support claims for 1 month is, I think it's almost 5 times what the national income average is.
Yeah.
Like, it's crazy. It's crazy.
That's the lifestyle they're living. But if you go to divorce, right, you're gonna take a chance and, you know, expose all that. All right. So unique problems, privacy issues. Yeah, definitely 53%. Business valuations. Well, Jason's going to talk about that. 67%. Reported income doesn't match the lifestyle. That's sort of what we're talking about throughout this, the presentation today. 67%. Uncooperative clients. Yeah, 38%. Third party cooperation. Jarret's going to talk about that. 22%. And other, please put it in the Q&A box. So thank you everybody for answering that poll question, and it ties in neatly with the importance of disclosure. So Jason, you want to take the lead on this one?
Yeah, I can handle the first couple points on this one. We're talking about obtaining disclosure here, which is interesting because we just talked about how important privacy is. Privacy and security. Now we're talking about disclosure and putting everything out there about your financial situation. So unfortunately, that's something that has to happen in a separation. And let's talk about the importance of quality record keeping. I mean, this just can't be overemphasized. Quality record keeping is needed to provide accurate and fulsome disclosure. This will help you avoid problems and issues, and it will add credibility to your situation or your position or whatever the situation is. If you do not have good accounting or record keeping, it will be very, very difficult to prepare an accurate NFP statement, which is going to cause problems. And it will be very difficult to conduct a reliable business valuation or income assessment if there are business interests involved. I mean, disclosure requests can be quite onerous, time consuming, especially if it's a complex organizational structure with multiple companies. It can be quite onerous, but if you have good quality record keeping, it will make it that much easier. I mean, talking about onerous, I just reviewed a disclosure request, which was 25 pages long. There was only one company, and it was only dealing with the issue of personal expenses. That's crazy.
Yeah.
Wow.
Yeah.
Go ahead, Jason. Sorry.
Yeah. Okay. So moving income assessments and business valuations. This is where I specialize. So if you're working, I think the important point here on disclosures, if you're working with a CBV, a chartered business valuator, to provide a business valuation or an income assessment, there is going to be documents and information the CBV requires to conduct his or her analysis and prepare the report. You need to just expect this, and you need to be open, honest, and forthcoming. provide everything that's requested. Providing full disclosure on a timely basis will help to ensure an efficient process. And more importantly, it'll minimize the cost and the time. So disclosure issues are critical, especially when there are business interests involved.
Jason, just a little side question. What about these lawyers who are sort of arsonists and they use disclosure as a weapon, right? They make requests that are clearly not relevant, but they're just trying to either slow the process down or increase the expense. How do you address those requests?
Yeah, unfortunately, you do see that from time to time, and that is exactly how you respond. You just basically have to respond by saying it's unreasonable, it's too onerous, it's cost prohibitive, this type of information is not relevant. Like you have to fight back in those situations.
Yeah, if they're asking for information for dates that are unrelated to the relationship, clearly something's afoot there. But Carrie, any thoughts on obtaining disclosure?
Yeah, I agree with everything that Jason has said, and
nothing that I said.
Well, I agree with you too. So what I was going to say is that I like the point of relevancy.
Yeah.
And that goes, this goes for regular net worth clients and the high net worth clients. It has to be relevant. When we're doing our work, my firm or Jason's firm, we're just taking all the stuff that's irrelevant and we're setting it aside. So like, we want to make this everything easier for our clients, more approachable for our clients and for the legal counsel that we're dealing with. This isn't about making something more arduous than it needs to be. This is about, let's get to the right stuff. Let's get to the meat of it. Let's make sure that we're being effective for the clients. And that's how they're going to get a good result.
Yeah. Jarret, I know you and I have come across this several times, uncooperative directors and shareholders. What do you do?
Yeah, there's a few tools that you and I have both used over the years. Usually starts with a letter advising the directors that they have a legal obligation to provide the disclosure to the shareholders. A lot of times it's the excuse we get is the shareholder says, well, I'm not a director, I can't provide the financial disclosure that you're requesting. Well, there's a thing called shareholder oppression. Shareholders are legally entitled to the financial documentation in the director's possession. You can just advise the other side of that. And then if that doesn't work, often you and I, Russ, have dipped into court from time to time. So if you're in the collaborative process and you have a participation agreement that needs to be amended or has permitted for the odd exception to going to court, this is one of those times where it can be a good idea to activate that and have a judge order the directors to produce the year ends, to produce the financial disclosure that's required.
Yeah, and case management judges are all, I found, very cooperative. They know that you don't want to be there. They usually make the order at conference, and then they'll say, if this director or shareholder opposes it, they can come back on notice and we'll argue the matter. But every time the court makes an order in that fashion, we always get the information fairly quickly. And I think the other thing we need to be mindful, there's some seasonality to this, right? So if you got an accountant and it's tax season, you can expect that there's going to be some delay just because they have other clients and they're busy trying to meet deadlines. So you want to be mindful of who you're asking and what time you're asking. If you're asking during tax season, you're probably not likely going to get the information to June. That's been my experience. Simply because they're not ignoring us, it's just busy time of year for them. Yeah.
Russ, the other thing that I wanted to say regarding the uncooperative directors and shareholders is keeping in mind that that's not, the remedies, if you're in collaborative process or you're in litigation process, even if you're in collaborative process, we can still use different means in which to get that information. Yeah. And that sometimes may include us going to a judge and getting an order, even though we are in collaborative. So it's not like, oh, we're in collaborative and those remedies are off limits. I think it's important for people to know that lots of remedies are still available for us.
And I find, sorry, go ahead, Jarret.
I find usually the reluctant director, it's because of those privacy concerns that we talked about, right? So sometimes offering them a non-disclosure agreement, having the lawyers and the clients involved signing that ahead of time and sending that to the director and showing them there's an easier path to producing the income information that we require rather than needing to go to court. That usually does the trick.
And in fairness to these uncooperative, directors and third parties, they're probably thinking, I don't want anything to do with your divorce, right? That's the last thing on my mind. I'm running a company here. You take care of your own problem. I'm not participating. So you can see the mindset, right? They're running a business. They don't want to get distracted, but it's necessary to get the correct result. All right, we've gone long enough without a poll. So let's run a poll and see what our audience is thinking. So have you ever had a rich or famous client? Well, a lot of the rich clients I have don't want to be famous. I don't know what about you, Jarret, but they're pretty private people, right?
Absolutely. I would say much more so than the average file, for sure.
And they're real penny pinchers. They're rich for a reason. They don't want to have any unnecessary expense. A lot of them are amazing business people. Carrie and I had one. We're in a collaborative meeting, and the one party writes on one of my napkins some information. He goes, hands it over to Carrie, and he goes, "Oh yeah, and by the way, I own these other 3 corporations." It's like, where did this come from, right? Like,
It's like, oh, I forgot.
Oops.
It's just my mind.
that's full disclosure, right? A napkin during a collaborative, a note on a napkin during collaborative meeting, that'll hold up, right? As a business
Yeah,
valuation.
sure.
Jason, what do you think?
Oh, absolutely.
Yeah,
That's-
okay.
That's
Back
what
on
I do. I
napkin.
just give it to Jason and go, here you go. Here's all the disclosure I got.
All right, so let's see about our audience here. 29% no, 11% up to $1 million, 1 to 10, 35%, 10 to 100, 21% over 100 million, 5. So it looks like, 10 to 100 million seems to be the sweet spot in terms of wealthy families in Canada, that we were dealing with in Canada. There are a handful that are over, 100 million. Usually, I'd say 99% of those go into private arbitration or some type of private process to the public never even hears about. We'll talk about some of the ones that have escaped that spotlight at the end of this. But let's talk about small, medium, large size businesses. Jason, what does our audience need to know here?
Yeah, and I like the fact that we titled it small, medium, and large, because businesses of all sizes can be a source of great value and or income for shareholders and their families. But it's important to keep in mind they also carry great risk, and they can be a source of great problems as well. So I think I'll just get a touch on the complex organizational structure point first, because I think that's the first thing you really need to understand and document in a complex situation. What is the org structure? You need to understand the lay of the land. So imagine I have this situation. Imagine, there's a holding company and there's 21 investee companies below that, all operating in different industries, each with different ownership structures. So some subs are being held wholly, some they're minority interests. Some are related, some are unrelated, the other shareholders. All the investees have different fiscal year ends. Some are loaning funds back and forth to each other. It can be very complicated. It's very important to understand what you're up against. So get the documentation to understand the organizational structure. And if you are the spouse or representing the spouse with the business, with the complicated organization structure, remember you're going to need to explain this, and you're going to need to support and verify the org structure in an effective manner to minimize those problems going forward. So that's the comment on complicated organizational structures.
Just on that comment, and if you're in court, you're going to need to answer these questions to the judge too, right? Like, what I love about
Absolutely.
you, Jason, is you prepare a nice chart for counsel showing the relationships between all the corporate entities and the percentage ownerships and the structure. But a judge is going to have these questions for you. So if you don't have the answers, it's going to look like you're not doing your job. But go ahead. Sorry, I just want to throw that in there.
Yeah. How can you resolve unanswered questions or problems if you don't even understand the situation? So that's
Right.
where you've got to start. So that brings us to keeping funds in the business. Income and support implications. So, we all know shareholders can choose to extract funds from the business. They can take a salary or a dividend or a loan, or they can choose to keep funds in the business. Now, if you think you can reduce your income and support by keeping funds in the business and not taking out as much in salary or dividends, then I would say think again. Because the
That's
federal
so true.
child
When it's spousal support time, all of a sudden the business is keeping the money in the business, right? It's not available for distribution.
The federal child support guidelines here in Canada are designed so that income for support purposes for business owners is a quote, like a gross employment income equivalent. So that means they're going to look at all of the activity and the benefits that they receive from the company.
Right.
And on top of that, there's a section in the guidelines that require the consideration of what they call the attribution of pre-tax corporate income. So what this means is that income earned by the business that is available for distribution to the shareholders, but not necessarily actually distributed, well, that may need to be added to the shareholders' income for support purposes. Yeah. So that's just the comment on keeping funds in the business. If you think you're being tricky or fooling anyone, you're not. With family trusts, this we could have a whole session on family trusts, and we don't want to do that. But the important point, I think, is to be able to recognize when there is a family trust. So ask the question, and then right away get the trust agreement, because you want to again understand what is this trust arrangement? Who is the trustee, the executor? Who are the beneficiaries? What is the purpose of the trust? What does the trust own? You need to understand that at a bare minimum.
Trusts are really effective tax planning tools, but I have also seen them used to set up roadblocks, right, for family law claims. And it makes it quite complicated when you're involving trusts, right? It's going to be extra work to get to the bottom of what a fair result is. So Golden Goose, Jarret, we've done a number of talks with Carrie on this. What is a golden goose and how do we save it?
Well, I think we start with the presumption that separation and divorce, the reality is sometimes it ruins the family business. By the time people get through their divorce, they've either bankrupt the business or they've tried to play games, as Jason was just explaining, with what they hold. But one thing that we've done on files in the past is we've really tried to meet the client's interest with respect to keeping the golden goose alive and keeping the family business intact beyond separation, which is its own network of effort put in to try to do that. And but when it works, and we've done it on a couple files with this team where it meets everyone's interests, including the next generation of children who may be inheriting that family business. If you can work through the family disclosure in a way, and I think if you went to 10 lawyers, a lot of lawyers, automatically tell the clients it's just easier if the business is sold or liquidated or what have you. But that's often not what the family wants. It's often, even if a lot of our files, there's one spouse that is the dominant business owner, and then the other spouse receives the benefits from that business. And they've been doing that for maybe 20, 30 years. Well, there's ways to set up the separation and set up the agreement in terms we can employ that keeps that family business alive, keeps the cash flow of income to what I'll call the have-not spouse, the have spouse continuing to operate and manage the business. But we build in disclosure terms, we build in quarterly reporting. We make sure we almost treat the have-not spouse as a shareholder with rights to disclosure reports, and they can't be oppressed in the way you can set up the separation agreement. So we've done that on some files successfully, and the family really benefited from it.
And that's the genius of collaborative practice, right? If you go to court, the judge has a limited number of options, right? Give me the value, sell the business. They don't have, or they don't like, if and when scenarios or legacy. The court's not going to give you an order dealing with the business owner's next spouse and how that's going to be treated, right? That's just not an option on the table, but you can be fairly creative when you do it collaboratively. We're going to get into that some more, but let's talk about the role of adult children in the Greek chorus, because oftentimes these adult children are working in the family business, right, Carrie?
Oh,
Or
absolutely.
they're on the payroll. I don't know if they're doing any work, but there's, tell me.
You know, whether they're in the business or not in the business or somehow involved on some peripheral level, you know, adult children in the business can cause some large problems. A lot of times, and we've touched on this a bit, you know, parents have set up this company, it's earning. Sometimes it's because they want the legacy to live on, and one of the children are going to, either one or all of the children are going to come into the business. What becomes interesting then is about how do you also protect the business on the long term. So there's a lot of legacy planning that needs to go on. And this is where I say to people, you know, if you have children that are in your business or are going to inherit your business, you really do need to be looking at those relationship agreements, and not 2 days before people are getting married or anything like that. We want them to be looking and considering those sorts of things as part of legacy planning. And it's a big deal. The children, though, can also become what is called the Greek chorus, where they're now telling one or both of the parties, depending on who they may have aligned with at the time, what they think that they should be doing with the business. And it's usually self-serving. It's not usually in the best interest of the business or in the best interest of the parent. So we always have to keep in mind, our Greek chorus, though, doesn't always have to be a family member. It can also be a business partner. Yeah. It can be another shareholder. It can be the spouse of your business partner that's coming in and chiming in as well. So we need to watch those sort of things, because we have to realize that when a business owner is going through separation and divorce and they have a business partner, the business partner, first of all, is feeling horrible for their partner, but also all of a sudden they're going, what happens to me and what happens to my lifeblood and my business and my livelihood if this thing all goes to hell and somebody decides we're just selling everything? What does that mean? So we do have to pay attention to those people, and as we're going through these files.
And as counsel, you always want to be mindful, right? You know, is my client being pressured? Is there undue duress? Like, these adult children in our Greek chorus can be a nasty bunch at times. I had a client, you know, it was necessary to sell the family cottage. The adult children said to my client, who happened to be the wife, you're not going to see your grandchildren anymore if you keep pursuing this, right? What a, you know, excuse my language, shitty thing to do. And it really affected my client. Fortunately, we're in a team environment where we're able to bring in our family neutral and talk about it. But you got to be mindful as counsel, is my client really making a good decision here, or is there something going on, right? Are the adult children coming into play? Are there extended family members or friends in the community? Sometimes even the church will pressure people into continuing with a relationship that shouldn't continue. Yeah. So be mindful of the Greek chorus out there, but thank you for that, Carrie. I think we've gone long enough. Let's get a poll question up there. What are the most difficult assets to value? So we'll give everybody a chance to answer this, but did you want to chime in at all, Jarret, on the Greek chorus?
Yeah, I think just while people are filling out the poll, I find there's added pressure, and maybe there's a little bit more prevalence of that factor in our collaborative files when they are the wealthier files. I've had the same situations as you, Russ, where, you know, a 20-year-old child is yelling at the mother because, you know, the father said, I'm not going to pay for your med school in London, England, because she's asking for too much spousal support. You know, these higher end files, I find that a little bit more prevalent, that you're getting some influence from the party's children, and especially those business ones that we're talking about too, with the business valuation. If they have a staked interest, if they think they're going to be taking over that business later on, and one of the two parties, what they're asking for in the settlement may affect that, they get vicious. You know, you hit the nail on the head. So we have to be cognizant of that in the process and not just shut that out and say, okay, well, children shouldn't be involved in family separation files. We have to actually, factor that in and maybe get a voice from the children and work out a resolution that encompasses their future holdings.
Yeah, it's these unknown knowns, right? You've got your client in the office, but you got to think, okay, who's in our community? What's being pressured on being brought into the room that I'm not seeing? But let's see what our audience thinks about disclosure. Cars, boats, planes, 5%, contingents, interests, 56%. Well, that's good. Goodwill, 66. That's going to keep you busy, Jason. Realty is 31, intellectual property, 58, other. You can put in the. So yeah, I think our audience is just hitting the nail on the head here in terms of some disclosure issues that are unique to these wealthy families, right? Yeah.
I got to tell you, Russ, though, I still say the hardest thing to value is the offshore Turks and Caicos account that nobody's giving you any information on. That's still the hardest one to get a value on.
Well, I'm sure CRA will be interested in that account, but even if you're an athlete or if you're an actor or someone famous, how do you measure the goodwill, right, on your future earnings or your next movie or your next sports contract? All right, so let's get into process options, advantages and disadvantages. Jarret, what does our audience need to know?
Yeah, so with these rich and famous separation situations, first option we'll talk about is court. The benefits of court, of course, is that you can get orders for disclosure. So sometimes, as we've talked about, some of the most difficult matters we deal with in the collaborative process in terms of getting that disclosure, because often it's complicated and it is tricky and there's multiple corporations. One positive of course, is we're going to get a court order for the production of that disclosure. I don't have to go on about the drawbacks of court, the cost, the time, the privacy issues. I've never dealt with a big money file where there isn't some ego involved and they just don't want their name showing up on the local court docket. There's those elements too, and those are the drawbacks of court, of course. Closed mediation, alternative dispute resolution, arbitration, that's another option. You could go with these big money files. Obviously, the closed mediation, they get the privacy ticked off. They think if they go to mediation or arbitration, there'll be some privacy to it. So that's great. But then there's obviously drawbacks with that process option as well. Sometimes depending on the arbitrator, they're stuck with that decision, they're stuck with that award. The closed mediation, sometimes they don't have counsel present. When we're dealing with big money, one mistake on the NFP, one mistake in the SAGs, that's a lot of liability. So
it's going to exceed your insurance probably, right?
Yeah. The one takeaway from this session, up your insurance professionals. But
buy the extra, what is it, 3 million you can buy or something like that?
That's it. Get your extra. So if you're going to be doing these files and working on these files, and then collaborative is obviously a popular option for us, and collaborative. I always use this line with clients. If I'm on for what I'll call the have client, not the have not, one of the pitches I use with them to do this in a collaborative way and produce the disclosure that Jason or Carrie may be looking for is think of it as at court, they're going to rip your engine apart when it comes to the disclosure. In the collaborative, they're going to start maybe by just popping the hood and having a look at the engine. So there's the path of least resistance with my experience on these big money files, where we need to get enough of the cards on the table to be able to make sense of things, as Jason was talking about, but maybe there's an effective way to do that that's not going to ruffle too many feathers for the other directors or the other related parties involved with that company or multiple companies. So that's why I think collaborative is a great way to deal with these big money files, because there's usually a compromise there. And then we're circling back to the heart of it is, can we save the golden goose? Is there a way to use one of these process options or a combination of these process options without completely blowing up the family business, which is what everyone in the family, second generations included, want to preserve.
That's usually where the supersized teams come in. And that when we talk about this, you're bringing in tax experts, corporate lawyers to help with the language that would go in the separation agreement. There's legacy planning, right? What happens if one of them dies or a new partner comes in? This is if you're saving the goose and the business is going to continue to operate and the two spouses are going to benefit from that business in the future as opposed to liquidating it. You know, you need to think about all these potential contingencies, and you bring the great thing about a supersized team, you do something called issue identification, right? Jarret and I had a case, we thought the agreement was great. We brought in the experts and they go, well, what about these 12 points? And go, oh yeah, that's a good point. Let's revise the agreement, right? But having a team, you can collectively identify these blind spots and these risks that you wouldn't necessarily find at a case conference or in closed ADR or whatever the process is that you choose. All right, so let's get into dividing assets. We're at our midpoint and we're 10 minutes behind, but we're having so much fun. Let's keep going. Jason, this is yours.
Yeah, I'll take a couple of these points.
Is that your car, by the way?
Oh, yeah. How'd you get a shot of that? So let's talk about dividing assets. I mean, when there's a separation, we need, division of property, dividing assets. You need to value the assets. So what if there's been a corporate restructuring? I'm going to stick with my theme, which is gathering information to understand the situation. So if there's been a corporate restructuring or plural, be aware if they've happened and understand them. They could be estate freezes, rollovers, capital gain strips, family trusts set up. They could result in a change in ownership, transferring assets to related parties. Like usually these things happen, there's a tax purpose behind it. And so you may need to talk to the tax accountant or tax lawyer to understand, get the documentation to understand what happened and how it affected or impacted ownership and shareholding in each year that's relevant. So that's my point on the corporate restructuring. Delayed equalization payments. Anyone want to comment on that?
I can comment on that. I just had a file actually where that's one of the benefits of these big money files is usually there's more options in terms of payment terms, especially if there's a couple different companies. A lot of these people have endless credit with the lenders and the banks. I just had a big farm file. Shocker. I practiced in Lindsay, Ontario. I had a farm file. But the way it got done is there was a delayed equalization payment over the next 5 years, and they're able to capitalize on shareholders' loans from the one company. There's lots of retained earnings in the one company. And basically the payer spouse is just going to take a shareholder's loan progressively over the next 5 years. And obviously there's some trickery to that as well, but there's sometimes that's the crux, right? To get the deal settled is to come up with those payment terms. So delayed payment equalization payments on these big money files can be a great asset.
You want to be mindful of the market too, right? We just came out of COVID, and lots of files I've been involved with, we've decided to hold off for 18 months. We didn't know how COVID was going to affect the business. Was that industry gone now, or is it going to bounce back? So sometimes delaying that part of the equalization process makes sense, just because the market conditions are so difficult for us to reasonably come up with a fair settlement. Sorry, Carrie, I cut you off there.
That's okay. I was going to say, one of the best advantages of a delayed equalization payment is absolutely restructuring for tax. So making sure you're doing things in the most tax efficient manner. I don't know about you guys, but I do not enjoy writing my tax checks to the CRA.
That goes to our next slide. So keep talking. This is great.
So that's my thing, is that we always want to be doing some form of tax planning. We want to get, if we need to, getting their accountants involved. We want to be getting tax experts involved where we can. There's a lot of stuff that we can do at my level of a financial analyst for divorce, a lot of things that Jason can do as a CBB, but there is a point, there's 47 different disciplines within finance. We're not experts at all of them. And so sometimes we need to go and jump into the real experts of finding who's going to be doing that tax, what's going to be the most efficient. And, you know, if it means structuring and staggering an equalization payment, then it's the best thing for the family as a whole. And I always want to stress that to clients, is that it's not what's best for one. We don't decimate one for the pleasure of another. We want to do what's best for the entire family, and tax planning comes into that.
And most family lawyers are not tax specialists, right? And if you're dealing with complicated corporate structures, you're going to want to, usually the corporation will have a tax specialist helping them, or you're going to want to bring one in to provide you with that component in terms of what's the best recommendation moving forward. So great tip.
With that, Russell, you have to remember what is allowable by the CRA today may not be allowable by the CRA tomorrow. So, and we're all at the mercy of the CRA. It's whatever they say at the end of the day is the way it's going to be. And we cannot write ourselves out of what they will do.
But a lot of our clients are American or have American business interests, and the IRS or in the tax department in the US will treat support payments differently. I think Trump made the change. Then it's treated in Ontario, right? So you want to be mindful, it's not going to be deductible in the US where it ordinarily is in Canada. So let's talk about support, which is our next topic. We've got incomes over 350,000. You want to take a crack at that, Jarret?
Yeah. So these big money files, they fall into this unique category of cases, and the Ontario Court of Appeal has grappled with this over the last few years. There's 3 cases, and this can be maybe put in the notes at the end. But there's 3 main cases that we kind of take a look at, and it's this idea of this $350,000 cap from the SAGs. So when you're looking at someone who maybe has 1.2 million in income, when we're looking at spousal support anyways, there's always been this cap we refer to, or a ceiling of the 350,000. And basically this case called Hallowell has been referred to for years, but basically what it sets out is that what we should be doing in our collaborative process, or what the court should be doing, is averaging between the parties' actual income in this $350,000 ceiling that the SAGs use. And there's been a recent case that has come out that's kind of turned Hallowell on its head. And what it's basically said is, in Hallowell, they took the party's actual income, 350,000, and they averaged it. And they then got an income to run the spousal support calculation. This new case that will be in the notes for the presentation, Plez and Herjavec, I'm probably pronouncing that wrong, but it basically says you don't have to take a midpoint. You don't have to average. What Hallowell was really saying, and what the Ontario Court of Appeal wants us to be doing in Ontario with these big money files, is taking a look at the payer spouse's income, comparing it to 350,000, and using that as the range. And then, of course, we have the freedom in our collaborative files, or the court does as well, to put the income anywhere in that range, including the actual income, or right down to 350. So for collaborative, it's great because it gives us lots of flexibility. It gives the income determination professional like Jason or Carrie to really do a fact-specific analysis. And that's really what the Court of Appeal was saying, is you don't have to split in the middle. You don't have to use one or the other. You can pick a number somewhere in that range. And that's what us collaborative professionals love to do, right? Give the clients that spectrum and say, okay, let's talk about this. Where do you guys fit in that range? That's
where the wine budgets come in, right?
That's right.
And for our non-lawyers, SAGs, our spousal support advisory guidelines. Carrie, Rule 65, 30 seconds or less. What do we need to know about this rule? Not everybody's mindful of it, but
age plus time or length of marriage. If it's over 65, it comes up with indefinite support. Keeping in mind, indefinite does not mean forever. It just means we cannot ascertain a timeline. we're kind of careful with this rule sometimes too, especially if it's close and it's a very short-term marriage. There's lots of things around it. The only other thing I want to say about incomes, though, is that the one thing I've noticed, we have a lot of clients that end up what I like to call SID, sudden income deficit syndrome, where we have to, the company never made this much money before and never will again. I've never made this much in commission before and I never will again. So averaging incomes usually can calm down that rhetoric as well.
Yeah, Rule of 65 is a good tool, but it's not the be all and end all. I would advise clients about repartnering. You get remarried. Rule 65 is sort of at the lower end of the judge's consideration. Likely your support will be, they'll do a step down and will likely end if you repartner, depending on the facts of the case. But it's certainly, it's a really good tool if you're advocating for the support claimant. Considerations of large capital payments. Keep this in mind. So if your client gets a $10 million equalization payment, that could potentially be earning income, depending on what they do with it. And that income can tie into the support claim. So, you know, interest rates are all over the map now, assuming they're earning 5% on 10 million. If it's in a safe investment, you know, your support claim is going to be one of the factors we're going to look at. Okay, well, that's income that's available to you, and your support claim should be adjusted accordingly. So just be mindful of large capital payments made during the equalization process. New partners, we kind of touched upon this a little bit. You want to think about it in legacy planning if you're saving the corporate, if you're saving the golden goose. You want to think about it for future support claims, how your existing support claim is going to be affected. But what do you think of new partners, Carrie? Any tips for our audience?
Honestly, my best thing for everybody is if you're having a new partner, you really need to look at those relationship agreements in which you're contemplating. I like to call it a 3D conversation. You're talking about divorce, you're talking about disability, and you're talking about death. I think it's something that everybody should be doing, whether you're high net worth or not. But with
That's
especially
a depressing conversation.
I know. Like, I know it doesn't sound good, but you know, there is some research that supports the fact that people that have relationship agreements actually have better relationships because they have those hard conversations than the ones they don't want to have.
Yeah.
So it's never a bad thing.
Jarret, any tips on new partnering?
Yeah, well, I liked what you said about the step down. I think it draws back to the cases I was referring to, that talks about the fact that once the equalization is determined, you know, that has to be factored in to the support, and so does the new partners, and so it's a, you know, it's a holistic analysis there. But the only thing else I'll add is, you know, be very wary of adding new partners to any of these business assets, or, you know, and of course, professionals need to be mindful of coaching their clients towards cohabitation agreements, very protective and detailed ones, as well as new marriage contracts. And there's tools out there to make sure that all parties are protected, including the new partners. But we need to be putting that information into the client's hands.
Well, one case that we had, my client was the wife. She continued with her business. She didn't want anything to do with the business, but she continued to own it. And there was mechanisms to deal with the business when it was to be wrapped up, or when one of the parties died. But the other thing we added in was the husband's new partner, if he gets married, he was required to enter in a domestic contract honoring the existing separation agreement and those provisions, which was crucial, right? Because otherwise the new partner is going to have a claim to all these assets that the wife originally thought she was going to maintain. So want to think through the box on that. All right.
The other thing, Russ, just I'll add to that, another great tool to keep in mind is the estates lawyer added in the clause for us. We had a supersized team on that one, added in that the husband couldn't change the will. Certain assets in the business were going to the next generation.
Right.
And the husband and wife actually had a mutual wills contract done up by the estates lawyer that was appended to the separation agreement, so that the children were protected from the husband adding or leaving shares to the new partner. So it was a kind of a complete circle there that everyone was protected as part of that agreement.
And most family lawyers don't do will. A lot of them don't do wills, right? And so you want to think, okay, I'm going to need to bring somebody in to help me with that one little part. All right. So what's your favorite favorite infamous celebrity case? Let's see what our audience thinks. And we're going to do a quick wrap up and then do some Q&A. So what are our poll results here?
Oh, my favorite's not on there.
Shannon, do you have poll results for us? All right, here they come. All right, Tom Cruise, 9%, Bill Gates, 40%, Brad Pitt. Well, everybody loves Brad Pitt and Angelina Jolie, right? They love following that dog's breakfast of a divorce. And other, you can put it in the Q&A box. So this leads us to famous and infamous. We're not going to name names, but I'll start. I'm thinking of an NHL player that ended up in motions court in Toronto for support. All the media was all over it. It was Toronto Maple Leaf. And very quickly they went to close arbitration because his brand was being damaged. But what's your story? You want to go next, Jarret?
I had one with a country singer, and it was a messy separation. And same thing, as soon as the idea of court got thrown out there, they quickly settled. It was almost immediate, because that's when we're talking about these big money files. The celebrity ones especially have come with their own unique ego and privacy concerns, right?
Yeah. All right, Carrie?
I actually have two that I enjoy. I had one where they were people that did home renos. They were always interesting, and then it was about what do we do and how do we value some of the works they had in progress. So that got really interesting, but they quickly learned the value of being in the collaborative process and how this actually helped save their brand for their television show, which was huge. My other favorite, I'm sorry, I'm naming names because it was on our list, are the McCains, and the fact that she gets $175,000 a month in spousal support. I married so badly.
You got to buy shoes. One of our audience member put in Johnny Depp and Amber Heard. Boy, that was a train wreck. Jason, what's your pick?
Lost my volume.
I can hear you.
Yeah.
Can you hear me?
Yep. Do you have a pick for us, Jason?
Comment to close this out with infamous is not a specific case, but when I think of infamous, I think that you're famous for the wrong reasons.
Right.
And when there's a business involved, and I see a lot of this, are you receiving unreported cash income? Is there a lot of unreported income? Are you concealing or hiding assets? Or are you even deferring or diverting income to somewhere else? So the message is, don't be famous for the wrong reasons.
Yeah.
Great point.
Yeah.
Great point.
And as soon as the media picks up on it, you can't control the spin that they put on your case. And usually your brand and goodwill take a big hit. We've seen that certainly with Johnny Depp. But let's bring Shannon back on. Welcome, Shannon. You want to bring this train into the station for us?
Yes, so just want to thank all of our panelists for joining us today and for sharing their time and expertise. We really appreciate it. And thank you to our audience for joining us and for all of your participation and questions. We hope a lot of the questions were answered throughout, but we should have time for at least one question here. But just before we get into it, I just wanted to remind everyone that there will be a survey that pops up following the webinar. And if you could please provide your feedback, it allows us to continue to grow our series, and a sign of our appreciation, we'll be sending you a complimentary ebook. But just getting into Q&A. So one question that we received from the audience here is, what do you need to watch out for pros and cons of using a butterfly transaction in business buyouts between spouses?
That's a 1-hour program. Right. Jason, 30 seconds or less, butterfly transactions.
Yeah, look, I'm not a tax lawyer or tax accountant. Carrie may have some thoughts, but all I know is there's a lot of technicalities and a lot of criteria that needs to be met in order to be done effectively and properly and not trigger adverse tax consequences. So you need definitely professional advice.
Yeah.
Bring in the tax lawyer. Okay, back to you, Shannon.
Great, thank you for clarifying that. So just want to thank everyone again. And as I mentioned, we love hearing from our audience. So there will be that survey, but also if you have any general comments or questions for our team, please feel free to reach out to me at shannonrussellalexander.com. And for anyone who is new to our audience, I just want to mention that we do host these bi-weekly on Wednesdays at 12 p.m. Our next presentation in light of November being Domestic Violence Awareness Month, we will be hosting our next virtual event on November 16th, and it will be focused on divorce and domestic violence. And I'll make sure to share those registration details with you in the follow-up email tomorrow, along with some additional show notes from today's presentation. So that wraps up our presentation today. We just want to thank everyone again, and we hope you have a great day.
Thank you, Jason, Carrie, Jarret, Shannon, great job. Don't
Thank
forget,
you.
if you're interested in CP training, Carrie's got training starting next week online, couple, what, 4 or 5 hours a day, something like that?
It is Tuesdays and Thursday afternoons from noon till 4. It runs for the month of November. So it starts on the 8th and I think we're done on December 1st is our last day.
And I think there's just a limited number of spots available. So if you're interested, sign up. But thank you guys. Great
I'll make
presentation.
sure to
as
share those
always.
details tomorrow in the follow-up email as well.
1 o'clock, right on time. Have a good afternoon, everyone.
Thanks,
Thanks,
everyone.
everyone.
Thank you.